Music.
Okay, got it. Wait,
Not yet.
bye.
All right, good afternoon. Today is Thursday, March 30th, 2023. We have a few bills on the docket. We're going to begin with House Bill 1071. Next we'll have I'm not going to go any further. We're going to start with 1071. Delegate Crutchfield, please take the podium. Thank you.
Yes, sir, Mr. Chair and Senators. Wonderful to be here. For the record, I'm Delegate Charlotte Crutchfield, and I represent Montgomery County District 19. And I'm here to provide testimony favorable to House Bill 1071. So on July 1st, Maryland will join 21 states, along with Washington, D.C. and Guam, which have acted to legalize recreational cannabis. This will change the narrative going forward for citizens of Maryland, including the reason that citizens should be investigated for possession of cannabis. Because cannabis was illegal, the smell of it gave officers the probable cause they needed to justify a search. But now the odor of cannabis will no longer provide ironclad probable cause because possession and smoking will not necessarily be criminal. There is unsettled law in Maryland around this issue. 2 years ago, the Maryland Court of Special Appeals, now called the Maryland Appellate Court, ruled that police couldn't stop a person based on the smell of cannabis. But last year, the Maryland Court of Appeals, now called the Maryland Supreme Court, overruled the appeals court, deciding that police could stop someone if they smelled of cannabis and if that person could briefly be investigated by the police. However, the state's top court said the law enforcement must let motorists go if they could not determine whether a stopped motorist had more than 10 grams of cannabis. House Bill 1071 seeks to prohibit police from using the odor of cannabis as the sole basis for establishing reasonable suspicion or probable cause for possessing contraband or other criminal activity. Specifies that certain types of cannabis-related evidence may be factors in the totality of the circumstances leading to investigation, arrest, or a search in relation to a person driving, operating, or controlling a motor vehicle or vessel while impaired by drugs. House Bill 1071 seeks to establish that evidence discovered or obtained in violation of the bill is not admissible in a trial, hearing, or other proceeding. And it finally reduces the fines for smoking cannabis in a public place to $50 for the first offense and $150 for subsequent offenses. So here are the key points I would like for members of this committee to focus on regarding this bill. HB 1071 makes clear that officers may consider the odor of cannabis in the totality of the circumstances when investigating a DUI. Therefore, the passage of this bill will not impede law enforcement's ability to investigate incidents of impaired driving. In Maryland, police are 4 times more likely to subject Black drivers to a warrantless search and their vehicles during traffic stops than white drivers. For incidents involving Black drivers, probable cause is used to justify 67% of those searches. While cases involving white drivers, probable cause was only used to justify a search in 46.1 of those incidents. This proposed bill would eliminate opportunities for officers to abuse the discretion afforded to them in these situations and reduce opportunities for racial profiling on the road. Many Marylanders support the banning of odor stops and searches. A statewide poll conducted prior to legalization found that 65% of voters were more likely to support legalization if it includes stopping the practice by police of using odor of cannabis as a probable cause or justification to perform a warrantless search. Marylanders should not fear police interactions because of the lingering odor of a now legal substance. Ensuring that the odor of cannabis no longer provides probable cause to search a vehicle or reasonable suspicion to stop a person will close a major gateway to criminalization and unnecessary interactions with law enforcement. For these reasons, I urge a favorable report on HB 1071. And so I have a few folks that I'd like to bring up.
Yes, we'll take questions at the end of the panel. Do you have a sponsor panel you'd like us to?
I do.
Come on up.
Okay, let's see, I have Michelle Hall. And I'll let Michelle go first, and then we'll have 2 other folks, Yannette, Emmanuel, and also Mr. Billy Murphy.
Yep. Are they both here?
They are on their way.
Oh, excellent.
Downstairs and got.
Okay, got it. Oh, excellent.
Yes, good afternoon. My name is Michelle Hall with the Office of the Public Defender, here offering testimony in support of HB 1071, including a proposed amendment. I know that we've been before you all before on this bill's cross-file, SB 51, and so I'll focus on really the things that are new. First, regarding our proposed amendment, which is regarding the exclusionary rule. The remedy that is provided by courts when evidence is seized in violation of the 4th Amendment, so when you have an illegal search or seizure, is that evidence is excluded from a subsequent criminal proceeding. This is really a foundational principle that is essential to enforcing the 4th Amendment because it deters police from conducting what would otherwise be unlawful searches and seizures. If evidence you seized is suppressed because of an unconstitutional search or seizure, that undermines all of your police work. But the Supreme Court of Maryland has stated explicitly that when the legislature sets out new rules for police activity, unless it provides for an explicit suppression remedy, courts should not read one into the statute. That is why evidence seized in violation of the Wiretap Act, for which the legislature did provide an explicit suppression remedy, can be suppressed, and evidence seized in violation of the DNA statute, for which the legislature did not provide an explicit suppression remedy, is not. Currently, the exclusionary rule is included in uncodified language of the statute. Our concern is that that is not the typical type of explicit suppression remedy that the court requires. Without an exclusionary rule, this statute is toothless because there's no consequence for violating the prohibition on stops and searches based on odor alone. We know of no other time the legislature has taken this approach to providing for an exclusionary rule, and the typical use of uncodified sections of statutes are for temporary provisions or to establish enforcement dates. Though it is clear that the intent for this exclusionary rule is that the evidence is excluded, we believe there should be no question and ask that this committee amend it to its original form, which is including the exclusionary rule in the codified language of the statute. I would note that even though our opponents may suggest that this should be litigated through the courts, it takes years for a case to wind through the system. And meanwhile, thousands of Marylanders will continue to be subject to arbitrary stops and searches based on the odor of cannabis alone. And we learned that lesson during decriminalization. At least 2 other states have taken the approach proposed here, and we ask this committee to adopt a favorable report with the amendment we proposed. Thank you.
Good afternoon, Chair Smith, Vice Chair Wallstreicher, members of the committee. For the record, my name is Yannette Emmanuel, Public Policy Director with the ACLU of Maryland. Here in support of HB 1071, however, we do urge the committee to consider an amendment to explicitly include the exclusionary rule, because without this amendment, this bill would essentially be toothless. As of July 1st of 2023, marijuana will be legal in Maryland, and there's no reason why the odor of a legal substance should continue to be used as a tool by law enforcement to stop and search people, especially when Black people are disproportionately stopped and searched. Allowing police to continue to do so not only promotes lazy policing, but is rooted in the subconscious or conscious belief that all Black people are inherently criminal. Marijuana odor stops and searches not only pose serious risks to people's Fourth Amendment rights, it enables racial profiling and dangerous unnecessary police interactions. Research shows that police are 4 times more likely to search Black drivers and their vehicles during traffic stops than white drivers, even though data shows that Black people are less likely to be found with illicit drugs and other contraband. Therefore, what we're asking this committee to do today is to recognize Black people's humanity. It is critical that the legislators step up and ensure that the law and the police practices are consistent with the reason that the majority of members of the Maryland General Assembly supported legalization of marijuana. And most importantly, that the law reflects the will of the people. The opposition will say that their ability to conduct odor stops and searches have yielded success to their public safety efforts, but they have not been able to produce any credible data to support this claim. Last year, there were almost 36,000 traffic stops in Montgomery County, and what we've learned from those is that it only resulted in a seizure of 172 guns. This is incredibly ineffective way to find guns and certainly not worth racially disparate harms to our community. Furthermore, the assumption that drug trafficking drives violence is not supported by research or data to the extent that there is data, it doesn't support this claim. In Baltimore's Western District, which is traditionally one of the most violent districts in the city, drug trafficking only made up 15% of the issues that drove homicides, according to Montana. Marylanders should not fear police interactions because of a lingering odor of a now legal substance, and legalization should do more than just allow recreational use of marijuana or the state to profit. For the foregoing reasons, the ACLU of Maryland and the Maryland Coalition for Justice and Police Accountability urges a favorable report on HB 1071. Thank you.
Excellent. Thank you, Delegate. So Delegate is Mr. I don't see Mr. Murphy here yet.
He's walking over.
Okay, excellent. So we'll go just to questions now, and then we'll wait for Mr. Murphy. Senator Sidnor has a question.
Yes, thank you very much. So I know it was testified to earlier by you, Delegate, that this bill would not prohibit an officer who may be observing someone who's driving, let's say they're swerving. They can then come in, they can do an investigation if they happen.
As long as it's not the sole, no, as long as the
Sole.
sole reason is not the smell or odor of cannabis. Okay, so they can conduct their usual stops. And I'll let maybe Michelle Hall just comment
Sure.
a little bit more on that, but yes.
Do you mind?
Yeah, to the podium.
Oh, okay, sorry. No, you're fine. So exactly what Delegate Crutchfield said is correct. Really what this bill says is that officers cannot rely on odor alone, possession of what is the personal use amount, or possession of the personal use amount in proximity to money, right? None of those 3 things, which are the hallmarks of what it would take to go into the dispensary and buy cannabis, can be the basis for a stop or a search. But if an officer sees a car that is swerving, for example, or runs a red light or something to that effect, they go up to the vehicle and they stop that vehicle, and then they smell the odor of cannabis. That is, we're compiling those circumstances together. And so under the totality of the circumstances, they may have a reason to believe that person is driving under the influence. But our concern here is relying on odor alone to indicate that someone is driving under the influence is really not sufficient for the concerns of the ways that odor can linger, isn't really connected to any type of recent use. And we should be looking to what are the hallmarks of saying someone is driving in a way that is concerning rather than relying on this odor that isn't really indicative of that.
In your experience, because I was talking with someone about this yesterday, I don't think you can't drive on any highway and not smell the stuff. But what I have not been able to do is to identify which car is coming from.
Exactly.
I just know the smell is out there, but I mean, in your experience, is that what officers testify to? That I mean, how do you even identify a car to pick in order to know where the smell is coming from? I mean, what have you heard?
So I think that really the typical fact pattern is that an officer conducts a stop maybe for a bad registration, a delayed registration, and they conduct a traffic stop and then they smell the odor of cannabis, and that is used to search the vehicle. That's the typical thing that happens. There are a lot less of cases that we a lot fewer cases that we see that are an officer is driving and they smell this odor and that's the basis of the stop, although that does happen. I know Delegate Taylor testified really poignantly in the House about an incident that happened with one of her children that was based on that. And so, again, the concern here is really if there's no way, there's a difficulty in particularizing it, difficulty in pointing out based on odor alone when someone ingested it, if that means that they're under the influence of cannabis, and that's not really a good proxy.
So going with your first scenario where they've been pulled over and have registration issues, this bill wouldn't even affect that because this is about the initial stop. So they've already been stopped, right?
So they've been stopped and they can issue a citation for the failed registration, but the fact of an odor of cannabis doesn't give you any information about what may or may not be happening with their registration. So that doesn't stop an officer from being able to conduct that stop in the first instance or to still issue that citation for a registration.
The last question that I had, I know it's been testified to that the bill doesn't have the exclusionary rule and it's in uncodified language, and I'm assuming the language that was in the body of the bill is on page 3, lines 15 through 17, where it says evidence discovered or obtained in violation of this section, including evidence discovered or obtained with consent, is not admissible in a trial hearing or other proceeding. Was that the language that you all? Okay, so help me to understand it being removed from here and put into section 3. How do you think that legally affects the fact that, I mean, uncodified language is still the law, right?
So uncodified language does still have the force of law. Our concern is that I have not come across any other time that the legislature has put in place an exclusionary rule. And really, without an exclusionary rule, this is just like, you should do this. But
I'm not.
Yeah.
I mean, I get it. I support an exclusionary rule being there, but what I'm asking is what difference does it make if it's in the bill, I mean, the body, or in uncodified language?
So from our conversations with DLS and also our experience, anytime there is an exclusionary rule, it is in the body of the statute. So the court has been very clear that the legislature needs to be explicit, and the times that they have found there to be an explicit grant is when it has been in the codified language of the statute. So we think that that's what the court is saying. That's the level that is appropriate.
But it says that section 3, and be it further enacted, that the exclusionary rule and its exceptions as judicially determined applies to this act. I mean, it's clear to me.
So, I mean, I'd say it's clear to you. I think this is what we want it to say. But I also think the court has been very clear that the legislature has to be explicit. And the thing that they have found to be explicit is when it's in the codified language of the statute. I'd also say, I don't know what it hurts if we have concerns that we are going to be fighting over this, about whether this is legally sufficient or not, because that is what the fight is going to be in court.
Because some state attorneys, if it's uncodified, they're not going to see it. And
right. And it's not, and typically when we pull up the statute on Westlaw, I don't even know that this is going to be pulled up in the body of the statute. So we're going to have to fight about what weight this should be given. What I don't want is for us to come back here in 2 years, 3 years, because we've been litigating this across the state, getting different results. We take it to the state Supreme Court and they say, well, this is not what we asked for. The DNA statute, not the DNA statute is what doesn't happen. The wiretap statute, that's what we want. And that's what we're telling y'all to put in. And so we think that if the intent of the legislature is to have this be an exclusionary rule, which I think that is what is reflected. I think that is what we're attempting to reflect here in this uncodified language. We should do the thing that is crystal clear and not the thing that is leaving any room for interpretation.
Gotcha. Question for Delegate Crutchfield. Do you have any information as to why it was moved here instead and taken that you can share?
Well, I have a little bit of information on that. Well, first of all, the chair of my committee felt that was the place where it should be uncodified. However, remember, this is about directing, right? Directing law enforcement, directing the judiciary. And that's why I feel strongly that it should be codified. And yes, so he and I agreed to disagree on that one,
Very good.
okay?
Thank you very much.
I think Mr. Murphy will probably further address what I want to bring up. And so if I don't mind, if you don't mind, first of all, Mr. Chair, thank you. I apologize. I regret I came in a little bit late, so I missed probably the bulk of your testimony. Senator Sidnor asked questions that I was interested in, but I just want to follow up because this has been a big concern of mine as well. And so looking at some of Maryland's cases that deal with this, I agree, even though they deal with different subject matter, that if we want to be clear and direct law enforcement and give guidance to the court that is explicit guidance and not subject to interpretation, then we should be very clear in our statute with the codified language. And so the one statute that resembles this most, maybe even goes a little bit further, is Virginia. The Virginia exclusionary statute on marijuana odor passed in 2021 makes it very clear that any evidence obtained as a result of an unlawful odor stop, search, seizure or of any person, place, or thing, even with a person's consent, shall be inadmissible at any trial, hearing, or other proceeding. And I think that is what we are looking for. Would you agree?
Yes.
And if anybody has any information when you testify about whether or not, you know, things have fallen completely apart in Virginia with law enforcement and them unable to do their work, please let us know. But I feel that given our history of extreme discriminatory enforcement, given the fact that the legalization is new, that we have to be very clear in our statute that odor searches alone are illegal, unlawful, and that anything that is obtained as a result of them is inadmissible in court. Without that, there's no deterrent for law enforcement to follow the law. Would you agree?
Absolutely. Thank you so much, Senator. And thank you for your bill also that deals with this issue as well.
My bill hasn't moved yet, but we keep
They were
hope
supposed
alive.
to be cross files, but somehow we kind of, you know, had a misstep with that. But thank you. Appreciate it. It's all good.
It's been a while. It's great to see all of you. I appreciate how hard you work. And my only regret is that they can't see it on TV as much as it actually happens. And I appreciate the questions that have been asked, but let me get right to the point. We need clarity. Wherever there's ambiguity, we lose because there are forces hostile to the exclusionary rule, even on our Court of Appeals. We are in lockstep generally with whatever the Supreme Court does. We call it being in pari materia with however the right wing on the Supreme Court decides these kinds of cases. And where they find a loophole, you can bet they're going to go right through it. They're going to find an exception, and we'll be back here next year or the year after that. And so there's no argument that is reasonable that can be made against as much clarity as possible. And if you've got the will to have an exclusionary rule, let's do it right. Let's make it clear and easy to understand and totally unambiguous, not contingent on what the Supreme Court does, as is what the current language would permit. And just say, we need this to stop the abuse, primarily of Black and brown people, on the highways of America and in impromptu stops. My God, the statistics couldn't be any more persuasive that this is a tool that is as invasive as possible. We got to stop it. And so let's pick the best way to stop it. Let's don't cut corners. Let's be clear and unambiguous. And by the way, I think almost all people of color have been either the victims of police brutality and police abuse themselves, or they have close friends or relatives who've done it. this is an issue dear to the heart of the Black and brown community. And please clarify it, make it strong. Let's get it done. Thank you. Any questions? All right, looks like I persuaded everybody.
Question.
Thank you.
Senator Sidnor has got one, then I got one. Go ahead, Senator Sidnor.
Thank you. Good afternoon. I wanted to
Nice
ask
to see you, by the way.
you as well. I want to ask the same question of you that I asked earlier. And I hear the argument for clarity. Is there a distinction between something being put in an uncodified section versus a codified section?
Well, that depends on the Court of Appeals now, doesn't it? And if it depends on the Court of Appeals,
Then we need to make it clear what we want.
that's correct.
Thank you.
Any other questions?
Sure, the question for you, Mr. Murphy, or the public defender, just so a couple scenarios. I mean, practical application. So smell is no longer the sole reason for the search or the stop rather. But let's say you pull someone over, broken tail light, and then the smell, maybe there's a clearer answer there, right? So you can't search under that. But what if you are the person that is swerving and you pull them over because you're like, that person looks under the influence of something. And then you go approach and then you smell. Is there a distinction between those two scenarios under this bill?
I think so. Look, let's be real. There are some people who abuse anything badly enough that they're a danger on the highway and they need to be stopped and arrested. I have no problem with that. But what I do have a problem with is legislation that doesn't make it clear that you can't have a pretextual reason for doing that. And pretextual stops are lawful under the Supreme Court. And so I have no doubt that without this kind of legislation, we're going to see many more pretextual stops than we've seen before. And so that's the other fallout that we have to worry about.
No, because the practical application, like the stops are not, the search is more practically speaking, because like you're not, like as we just discussed, like you're not going to stop a car because you think you smell cannabis. I mean, like it just, that's because that's like if you're seeing someone on the road or you're stopped, I've got a speed camera out, or it just practically speaking, when someone's driving a car, I don't know if you even practically can tell like, oh, the cannabis is coming from this car or that car or this car. So that's why I'm stopped. So I get that. It's the search piece that I'm kind of more intrigued by in terms of the practical application of the bill.
Well, cannabis has the reputation for being a gateway drug.
I don't believe that, but yes, I understand.
You're gonna see what I'm talking about.
I know what you're saying.
In a second.
Yeah.
A gateway to the complete invasion of the privacy of everybody in your car,
I mean,
and
I don't
every
personally believe
closed
that, so
container in the car,
Yeah.
and everything in your trunk. That's got to be stopped. And see, when you have the right because of the smell of marijuana to search, you can look for a seed. A seed can be anywhere. And so that gives law enforcement the right to stop a motorist who's going someplace, probably where there's a time constraint, and you're going to let them be searched on the side of the highway for an hour and a half while they tear the car apart. They don't have to put the car back together. And that's just ridiculous. And we've been subjected to that. This is something that happens to us. So whatever you have to do to stop it, let's stop it. Whatever language is needed to make it clear and unambiguous what the abuses are that we are trying to stop, let's put them in the bill. And let's get rid of this problem once and for all. We can do it. We have the political will now. God knows what will happen in 4 years. And while we have the political will to do it, let's do it in a way that prevents all of the known abuses of this police practice. And that's why I like the Virginia statute, because consent isn't really required and it's liberally granted, and the courts rubber stamp